Hello again. My name is Marty Frenkel at Maddin Hauser, and with me is my esteemed colleague, Corinne Rockoff. In today's videocast, we're going to talk about the variety of legal remedies a general contractor should have in its subcontract with its subcontractors. Each has different purposes and each needs to be understood.
So to take us through all of the options and how contract remedies can play out, let's use the example of Mike's mediocre mason. He's our new least favorite subcontractor, and as you might guess, he's about some issues on this job site. So for example, let's say that we're working on a mixed-use project that's some retail and some multifamily housing, and Mike is just nowhere to be found. He maybe started the project, showed up sporadically for a while, and we just can't get a hold of him anymore. What remedy might be appropriate in that scenario?
Well, under that scenario, it's a perfect one for termination. If we simply cannot get our subcontractor to continue performance, we need to keep the train moving down the tracks. We're going to have to terminate this mason and find a replacement mason as soon as possible. And so we cut our losses, providing that our contract so allows, and then replace them with a new mason.
And so you're looking to your contract terms. It's another place that no one can tell you your specifics except your subcontract, because you have to see how does that need to play out, what notice, all those details. The place to look for that is going to be in your subcontract.
That's correct.
So let's say that Mike the mason is doing a little bit better in this hypothetical. Maybe he has been showing up, but you're beginning to be concerned about the quality of the work. The work quality does not look the way that you would expect it to look for a completed product. What remedies might be available to you in that to address it?
Well, under that circumstance, I'm going to want the ability to direct Mike to engage in corrective work at the time during performance of the project, to immediately engage in corrective work. Because if I have that remedy and Mike fails to do that corrective work, I then may resort to my termination remedy. In addition, if Mike is not correcting his defective work, and for example, I retain Corinne's masonry to come out and correct some of Mike's work because I have no choice, I need to keep the train moving down the tracks, I'd like a specific remedy in my contract that allows me to set off against amounts that are owed Mike that I'm actually paying you, Corinne, so that I don't have to double pay.
Now, in a situation where perhaps the defects in the work don't become apparent until after Mike has left the job site, the work appears complete, and then lo and behold, perhaps you're starting to see the foundation shifting or settling, and maybe even damage from a partial collapse. Hopefully no one's injured in that scenario. But Mike is already off the job site. What remedies might be available to a general contractor in that scenario?
Sure. Well, if Mike's work is already done, but there's been a partial collapse, for example, or even you can see it starting to fail, I'm going to put Mike on notice of his warranty obligation. So unlike certain provisions that require correction of defective work during performance of the primary scope of work, a warranty requires a subcontractor to come back out after completion of their scope to correct defective workmanship for a period of time. So we would certainly put them on notice that they need to correct that workmanship.
So let's say that Mike is already off the job site. You've had to hire Corinne's masonry, well-renowned, well-respected masons to come in and do some after-the-fact repair work. There's been that partial collapse of the building, but it's significant. It's impacting some of the retail tenants who are supposed to be operating in there, and they can't open their stores. They are distraught. They're losing income. They're in a panic, right? Is there anything at that point that the general contractor can do to avoid dealing with those costs alone, to bring that back to Mike about his own faulty work?
Well, the answer is, unfortunately, there is nothing that the general contractor can do to ever force Mike back on the job site. However, there are also things that a general contractor must do in order to preserve its rights and remedies so it doesn't have to end up holding the bag at the end of the day. So what are some of those things? Well, hopefully you've required Mike to maintain insurance on the project and perhaps list the general contractor as an additional insured under that insurance policy, because you're going to go ahead and demand that Mike put his insurance company on notice from this part because of this partial collapse. You may tender a claim directly to his insurance company, and you're probably going to tender a claim to your own insurance company to make sure that at the very worst, insurance will pay for some or all of the damages. The other thing that should be done is hopefully your contract has a robust indemnification provision. An indemnification provision is a contractual remedy that, if it's drafted correctly, allows the general contractor to say, hey, Mike, and in this case, let's assume that Mike actually has assets and is collectible.
Not always true for subs.
Not always true, but hopefully in this case it is. That it says, okay, because if there is any damage on this job site, if any breach of the contract, any claims by third parties against me, the general contractor, like the property owner might be suing me because his tenants are going crazy over their inability to open their stores, that I have the right to recover from Mike all of the damages I've incurred, from paper clips to attorney fees to replacement masons, and it's a much easier claim in court to make. And by the way, the claim under the indemnification provision is different than insurance. There might be some damages that are not going to be paid for by insurance, but would be paid for under an indemnification clause if Mike is collectible.
Now, let's say that we as the general contractor have been incredibly unlucky in this instance, and we are stuck with Mike 2 different projects at once. One of them is going okay so far, but the other one, he has really, really missed the mark, and things are clearly going awry. Performance is not happening. Is there any relationship between those 2 subcontracts that can change how the GC can handle a contractor like Mike?
Yes. If you're planning ahead to deal with a subcontractor that you're using on multiple projects, you would want a cross-default provision in your subcontract, which says, hey, Mike, a default under subcontract A also means a default under subcontracts B, C, and D. Why would I want that? Because I can then exert leverage over Mike to come back and perform his obligations on project A where I've had this partial collapse. Or conversely, if Mike is starting to fail across the board and he's failed on 2 of the jobs and I'm afraid he's going to fail on jobs 3 and 4, I may be able to say, you know what? I'm done with Mike. I'm cutting ties because I don't want problems on these other jobs, and I'm simply going to say he's in default under all 4 now because of this cross-default provision, and terminate him on all the jobs.
Now, as the final line of defense, which obviously we all try and avoid at any time that we can, but sometimes it does come up, mediation, arbitration, litigation. Can you talk us through the differences between those 3 options and how they play out for GC?
Sure. So these are dispute resolution processes, and these provisions can be heavily negotiated within subcontracts as well as general contracts. And one of the things that we would want to do, by the way, is if we find ourselves in litigation with the project owner over Mike's failure of performance, we want to make sure that Mike is obligated to participate by virtue of our subcontract in a mediation with the owner or an arbitration with the owner if those are our remedies. If it's a lawsuit, well, then we can compel Mike to come into court. but we want all the parties at the table. And so these processes are slightly different. Mediation is more of a process that doesn't have such the leverage of a court or a judge sitting over you. It's an independent third party who has no stake in the fight, who is going to try and engage in shuttle diplomacy between us and Mike, or us, Mike, and the project owner to see if we can make a business deal to resolve whatever has occurred.
More collaborative solution.
More of a collaborative solution. Whereas arbitration and litigation, a lawsuit, are adjudicative proceedings. There is somebody, a judge in a lawsuit, or sometimes in arbitration, there could be somebodies, 2 or 3 arbitrators, lawyers that are appointed to go ahead and decide our fate. We no longer control our fate. We're going to put on witnesses, introduce documents, and someone is going to determine who's right and who's wrong, who pays, who gets money, and how much.
Both arbitration and litigation are a lot closer to what folks are imagining when they think of a courtroom or law and order, what have you. Arbitration and litigation are both on that end of the spectrum, versus mediation is a more collaborative process, and which is the right fit for a situation will come from what the owner requires and what flows through between all the types of contracts, as well as the specifics of that project and of the parties.
One of the key things, Corinne, about this whole discussion on remedies is that the general contractor needs to understand that, like working on a job site, there are many tools on a job site for on a project. Your subcontract should have many tools available to you. And sometimes you may need to use or should use several of those tools at the same time. And so it is important to ensure that you have all of these remedies in your subcontract, that you understand how they function, and that you have a process in place for ensuring that you are properly enforcing them when a problem arises.
The provisions in your subcontract are your toolkit, and you have to know what's in it, know where your tools are, and know how to use them. And if you have all those pieces together, you can really improve your circumstance, even when things are looking a little challenging, versus you might have tools that you don't even know are in your kit, but you have to be prepared to use them when the time comes.